My quiz on the California rulemaking process. So the first question is that the main principles of the Administrative Procedure Act are notice to the public and an opportunity to be heard. That is definitely true. Those are the two main tenets. Question two, an underground regulation is one that has complied with the APA process, and that's false. Actually, an underground regulation is one that did not follow the required process for a regulation to follow pursuant to the APA and the government code. Question three, the state APA dictates the process to be followed by state agencies in their rulemaking. Of course, that's true, and this is set forth in California's government code. Question four, there are 7 statutory criteria in the government code and the APA by which the Office of Administrative Law evaluates proposed regulations. That's false because there are actually 6 statutory standards, not 7. Question 5, like a bill signed by the governor, after review and approval by the Office of Administrative Law of a regulation, OAL in turn transmits the regulation to the California Secretary of State. The answer is true. It's basically a ministerial act. Question 6, deference is one of the statutory standards of review used by the OAL to review proposed regulations. That's actually false. This is not one of the 6 standards of review that are mandated by statute to be used. Question 7, any interested person may petition a state agency requesting the adoption, amendment, or repeal of an existing regulation. And that's true. This is actually permitted under the APA. Question 8, all agencies in the judicial or legislative branches of state government are exempt from the APA. That's actually true. And this exemption is found in the APA statute in the government code. Question 9, a so-called major regulation is one that is estimated to have an economic impact in excess of $100 million as estimated by the rulemaking agency. And that's false because the amount is actually $50 million to qualify as a major regulation under the APA. Question 10, a regulation or an order of repeal required to be filed with the Secretary of State becomes effective on a quarterly basis. And this is true, so long as that regulation is filed at least 1 month before the quarterly date. Question 11, proposed regulations are published in the California Code of Regulations. That's false. The CCR, as opposed to the register notice, the CCR is where the finished or finalized regulations are actually posted. Question 12, the publication of a regulation in the California Code of Regulations or the California Code of Regulations supplement raises a conclusive presumption that the text of the regulation as so published is the text of the regulation that was adopted. And this is false. It creates a rebuttable presumption rather than a conclusive presumption. Question 13, a regular rulemaking requires a minimum 45-day comment period. And that is true. It's provided in the APA. Question 14, an emergency rulemaking requires a minimum 10-day comment period. And that is false. The minimum is actually a 5-day comment period, and the comments are submitted directly to the OAL as opposed to the rulemaking agency. Question 15, an emergency regulation must contain a finding of an emergency that includes a written statement that contains certain required information. And that's true. This is a requirement that's found in the APA. Question 16, a finding of emergency can be based on just expediency or the general public need for an emergency regulation. And that's false. A finding of emergency based only upon expediency, convenience, best interest, general public need, or speculation shall not be adequate to demonstrate the existence of an emergency. Question 17. Agency publication of an ISOR or FSOR are part of the rulemaking process, and this is true. The ISOR is the initial statement of reasons, and the FSOR is the final statement of reasons. Question 18. A regular rulemaking project must be completed within 1 year. And that's true, and that 1 year period begins at the time of the notice of the proposed rulemaking. Question 19. An agency does not have to hold a public hearing on a proposed regular rulemaking project. That's partially true, but it's actually false, because if any interested person requests a public hearing, then the agency is actually required to hold it. Question 20. Necessity, authority, clarity, consistency, reference, non-duplication, fairness, and economical are the statutory standards of review used by the Office of Administrative Law to evaluate proposed regulations. And that's actually false. It's the first six that are listed in my list here, that are the actual six statutory standards. Necessity, authority, clarity, consistency, reference, and non-duplication. Things like fairness and whether it's economical or not are not applicable. Question 21. The Department of Finance reviews the standardized regulatory impact analysis, otherwise called the SRIA process, that's prepared by a rulemaking agency. And that's true. The statute says that DOF is required to do so from time to time. Question 22. An appeal of an OAL decision regarding a regulation can be appealed to the governor's office. And that's true. And this appeal by statute is to be specifically made to the governor's legal affairs secretary. Question 23. If requested by an individual legislator, a state agency must undertake a review of a regulation or group of regulations. And that's false. OAL, at the request of a standing committee, a select committee, or a joint committee of the legislature, is required to initiate, quote, a priority review of any regulation, group of regulations, or series of regulations that the committee believes does not meet the standards that are set forth in the APA. Question 24, only those parties that participated in a regular rulemaking project may bring a suit for judicial review of a regulation. And that's false. Actually, under the APA, any interested party may file suit. And finally, question 25, an agency can be exempted from complying with the APA by adopting a regulation after a public hearing. And that, of course, is false. An agency can only be exempted from the APA by an actual enacted statute enacted by the legislature and governor.